For 1 hour.
For 1 hour.
Yes. Right, Mr. Daniels.
Thank you, my Lord. As indicated to your Lordship in chambers, Mr. Barner, who appears for the fifth to the previous will start the actions. I will limit my address, Mr. Taylor, to deal with the specific nature of the circumstances of the first to fourth applicants. And in the circumstances, we have agreed that it is probably better advisable that Mr. Barner commence.
Yes, I don't mind.
Thank you.
Mr. Barner, as I've said to you, you must remember I've read the papers and all the heads of argument, for which I thank you and of course your colleagues. So you don't need to give all the background detail to me. I've read all that.
Your Lordship indicated in chambers that you received the amplification kits that were sent.
Yes, I received them late yesterday afternoon, but I did read them.
Sent with that was a draft order and a chronology for matters inquired, for which has those as well.
Yes. Tell me, let me just find that. Have you got a copy of the draft order? Mr. Barner, can I just tell you that I do have a number of important questions which I will put to counsel during the course of this hearing, but I also don't want to interrupt unnecessarily. You know, we only have today. So I will let you proceed the way you deem fit, but there will be a time when I need to interrupt you and put to you what I need to know. Can I just have a look at this draft order again? What's that?
The second document your Lordship has been received chronology.
Right, let me just write this down, chronology. Mr. Barner, can I just start with the basics? As far as the draft order is concerned, the hearing has been set down for December, which will also be in the nature of an urgent interim interdict.
It's part A.
Yes. And then part B will be heard when?
Part B is an application to be instituted.
Still to be instituted. Yes, just a sec. Well, I know that. So December will be another hearing similar to today, except if I look at your draft order, there will be further affidavits and so forth. But in essence, what do you say will be the nature of the hearing in December? Similar to today or not?
No.
So well, that you'll get to that, no doubt.
We will get to that.
Let me not deal with that now. I know that's what you say. Then the main hearing, if I can call it that, that will be part B. We don't know yet when that will be heard. And nothing has been done in that context.
The reason is that part B application is an application that's going to be instituted with a discovery order that's sought in that application.
But what will the relief in part B be?
If I can take your Lordship then to the finding papers.
Yes.
The part B relief, if you want to call it that, the second application is dealt with in paragraph 3 of the notice of motion at page 3, my Lord. And it's a declaration, essentially, I'm summarizing, my Lord, it's a declaration that the termination notices are invalid. There's the requirement then that in the alternative that reasonable notice be given. And paragraph 3.3 requires directing that discovery of documents in the application to be instituted shall take place in accordance with Rule 35 of the Rules of Court. 35 essentially, my Lord, with all of its
Discovery in the context
of an application, yes.
It's not an order that is likely made.
My Lord, it's not an order that's lightly made. There is provision for it, and that is what we will have to persuade the court in due course on.
So it's important for me to know, and I will obviously know what we are aiming at. What will be asked in the main application? That reasonable notice be given. No, what would that be?
That the notices of termination firstly are declared. Secondly,
Yes.
The period contended for in the papers for reasonable notice of the facts of this case is 24 months, or such period as the court may determine.
Right, let me just make a note of this. Reasonable notice 24 months. Now what that means in effect is that sometime next year an application will be made seeking this relief for a period of 24 months.
Yes, or if the court disagrees.
Yes, obviously the court may say, you know, that is too long, it should be 12 months. So that, what does it mean in practice? When would this Part B then be heard, do you think, keeping in mind how this court functions?
It's contemplated sometime in 2018. In the time when the papers were launched, my Lord, we of course didn't know the practical difficulty that Part A could only be heard in December. And of course, we're happy to take instructions on dealing with Part B on an expedited basis, my Lord. The bringing of Part B.
So it'll be, the result of this will be that from sometime next year, for a period of 2 years, the bank must keep this account open, if I can use that general phrase.
Persuade the court on the 2-year period.
Yes.
The court may find that it's a 3-month period, but essentially that's...
No, I know that. But I mean, that is what, in effect, what it will mean.
And my Lord,
against its will.
well, my Lord,
No, that must be so.
that debate that it's against its will occurs in any event where one is in the realm of a reasonable period.
Yes, but now we're looking at the particular relationship of bank and client.
What your Lordship puts to me is really an issue that goes to the period, because even at the moment it says it's holding these accounts open against its will, and whatever the period, the reasonable period, it will always be against its will, because it contends.
No, I know that, but I need to look ahead, and I want to know exactly what you have in mind, what you intend doing, and what the effect will be.
We have no intention of dragging these proceedings out, and we're quite happy. At the time this was launched, we envisaged we would be in court on Part A on the 15th of August. For a number of factors which we'll take your Lordship to, that didn't happen. And it was envisaged that the Part B, I think we provided, would be launched within 30 days of that. I speak under correction, within 15 days of that order. So that was what was envisaged at the time, my Lord. Of course, we now have to deal with the events that we have. But it was not my client's intention to drag Part B out, or indeed even to have dragged Part A out. So we're quite happy in due course to consider dealing with Part B on an expedited basis.
Can I just, I hope I'm not interrupting your line of thought, but it's important that I just get this back up. Now we know, of course, it's the client and banker relationship. And I know what relief you seek and so forth. If it were a normal contractual dispute, and the one party is seeking specific performance, would the court have a discretion in such circumstances to grant it or not? In a so-called normal contractual dispute.
That's the case where you seek specific
Yeah.
performance.
Now, is it any different in a banker-client relationship? In other words, what I want you to address me on, whenever you deem it appropriate, what discretion do I have in these proceedings, and how do I exercise it?
Discretion to come up today because we submit what your lordship is not going to be dealing with this part A today, let alone part B.
No, but will you address me on that topic?
My Lord, also just in relation to the period, if memory serves, if I can just look at the papers, the 2-year period doesn't run from the date of the order. It runs from the date that notice was initially given, which I think is the 6th of July. Yes.
2-year period from July this year. Any reason why you say 2-year period, or is that
No,
just a
we set it
coincidence?
out in detail in the papers, my Lord. We've said
No, but I mean, why not 18 months, and why not 15? Why 2 years?
we in the papers say that the period effectively, it's unlikely they're going to get another bank to give them a banking facility, and that's the period which they reasonably anticipate will be required to wind down their affairs, either by way of getting somebody to buy all of these businesses, or in winding out the businesses in a smooth way.
Now you can proceed, Mr. Bonner. I just want to know, at some stage in your argument, will you let me know what you say about my discretion in today's proceedings? Whether I have a discretion or not? Because we know in urgent interim application, the court has a overriding judicial discretion.
Just so that I understand.
The Varner judgment with reference to a number of previous authorities. So I need to be addressed by all counsel today. What discretionary powers do I have in this case, if any, and how I exercise them?
So that I understand your lordship's question clearly, is that does your lordship wish to be addressed on the general discretion you have in interdictory relief, or in relation to the issue of specific performance?
Well, we've overlapped to some extent, but in the context of today's proceedings. And what I'm aiming at, I mean, you would know what I'm aiming at, is that, you know, I may find that you've made out a good case. You know, good in inverted commas. I don't want to define the word good. And then the question would arise that despite you having proven element A, B, C, and D, do I have a discretion in this case before me today? And if so, how do I exercise it? I mean, that is important that you address me on that topic. But then proceed. This is just by way of background.
My Lord, if your lordship has had an opportunity to glance at the draft order, your lordship will see that it essentially seeks to preserve the status quo pending the hearing on the 7th and 8th. I'll deal with paragraph 3 in a minute, my Lord. In paragraph 4, provision is made for a timetable, my Lord, which in any case was considered and discussed in the hearing, in the case management meetings with the DJP. It was indicated that the applicants would be supplementing their founding papers. The DJP had certain requirements as to the period in which he wanted heads of argument delivered in advance of the December hearing, and essentially the timetable in 4 is to cater for that, my Lord. Paragraph 3, my Lord, is an insertion that we put in to deal with a point made by our learned friends for the respondent in their answering papers, where they say the relief that you seek effectively means that even if you're in default, if any of these applicants are in default of their banking contracts, if I can call it that, that we can't terminate. And paragraph 3 seeks to preserve that right that they would have contractually to terminate if there was in fact a default, if there's a breach. So it's really put in as an addition. We think it was implied in any case that they would always have that right, but it's put in to make that clear, my Lord, and to deal with any difficulty that they have in that regard.
Mr. Bonner, before you go to your main argument, I just need to know a number of other facts, which will make it easier for me. We know, of course, that this matter wasn't heard in August. I mean, that's obvious. And then, when did you find out for the first time that there would be a hearing today?
The hearing today. My Lord, my recollection, and I am subject to correction by everybody else here, was at the case management meeting on the Monday, I think it was the 14th of August, when it had become clear that firstly we were still expecting the respondents to file their answering papers, my Lord. At that case management meeting they indicated that they would be in a position, I think they said, to file by the Wednesday, and at that point it became clear that one would have to deal with what had been mooted in the correspondence already by the parties, that the hearing would have to be an interim. And what occurred was that the DJP said, put the respondents on terms to file their answering affidavit by Wednesday noon. And it was then said that for the purposes of the interim, if the applicants wish to file a reply for the hearing that was going to take place on the Thursday, they had to make that decision by 5 o'clock on the Wednesday.
Why I'm asking this is for the following reason. You will know that your colleague Mr. Khan said in his argument that it is significant that no replying.
Yeah.
Now, if he had known by mid-August of today's hearing, I just want to know why no replying affidavit was filed.
My Lord, the reason, if I can tell your Lordship, we had no idea as to what was going to be in the answering that needed to be responded to for the purposes of the interim. The answer was filed on the Wednesday, which I think was the 16th of August.
I'm not talking about now for the hearing of the mid-August. I'm talking about for purposes of today's hearing. And I just want to know why no answering affidavit was filed.
That's why it's important as to how events unfolded in that week.
But can you just tell me that why since August was no answer filed?
What was contemplated was that there was going to be a hearing on that. So, my Lord, what we basically had was 4 or 5 hours to decide if we were going to file a reply for the interim.
I'm not talking about that, Mr. Bonner. After that. After you were told, look, there won't be a hearing in August, there will be one today. I just want to know why no answer was filed. No reply was filed.
We made a decision to the DJP that we would not file a reply for the purposes of the interim, and we were bound by that. And what was put up by the what was put up by the respondents was then simply an affidavit on the interim, because we say essentially the Section 34 question is a legal question.
Yeah. Well, that is the answer.
Well, Lord, I don't want your Lordship to lose sight of the fact that we had 4 or 5 hours to make that decision if we wanted to have the interim hearing on Thursday.
Anybody for any decision taken in August.
Made a decision, and we understood, we bound by that decision that we conveyed to the DJP, because the matter would then have been heard at 2 o'clock on the Thursday.
I understand all that. I'm not, want to comment on what happened in August and what was said in the DJP's office and so forth. I just wondered why since then no reply was filed.
My Lord, it's because we're bound by the decision we had conveyed to the DJP.
No, but the DJP, with all due respect to him, of course, allocates dates. What happens in the court has nothing to do with him.
Yeah.
And if you decided that once you received the reply, no matter what you told the DJP, you would have had to take a decision to file a reply or not, irrespective of what you told him then, for purposes of the August hearing.
We accepted we were bound by what we had told him, that if we wanted the interim hearing, we had to forego filing a reply because we understood that was going to then throw out the hearing. But also, my Lord, the fact that having looked at what was in the answer, most of that, if not all of it, really went to the Part A relief, although it's said to be an affidavit for interim, and on the basis of argument which we will submit to your Lordship, we say that your Lordship is not hearing Part A today. We of course need to deal with those matters in due course before the Part A hearing, but for the purpose of the basis on which interim relief is sought, which is a very narrow basis, my Lord, most of that factual matter is really irrelevant.
Look, I'm really sorry that I'm interrupting you, but these are, things that I have to know before we start. There was something else. The nature of today's proceedings, whatever one can call them, is an urgent application for interim relief. Or not? Is it something else?
It of course is that, but it's not the interim relief that is envisaged in Part A. It's really to preserve the status quo so that the court can make an effective order when Part A is heard in due course.
Yes, but all interim applications, whether they pend a review or they pend a main hearing or pending whatever, by their very nature are proceedings involving interim relief. Even if you say, look, it deserves status quo, that is still interim relief.
But it's, my Lord, the basis of that is so that the court, in dealing with its procedures, is in a position to make an effective order.
Why I'm asking that, amongst others, you will, as the argument develops through the day, you will obviously know why I'm asking that. Because if it is, you can call it what you like. If it is interim relief, preserving the status quo, the question is, what do I need to take into account? I mean, that is an obvious question. And I must say, in my humble experience, I've never heard, for instance, a court granting interim relief if it is of the view that there's no prospect of the main relief succeeding.
So, my Lord, we say one must not think with the cap of the traditional requirements for an interim interdict in the sense of a prima facie case. Your Lordship is indeed correct that if a court finds, let's deal with the lower threshold first, that there's no bona fide dispute, it will, in the exercise of its powers, not grant interim relief. But the standard is not one where we convince your Lordship that there's a prima facie case on Part A. What we have to convince your Lordship on is that there's a bona fide triable issue.
Yeah.
Which is...
Well, that's how I understand it.
Indeed.
That's with your colleagues.
Indeed. Because otherwise, my Lord, we're arguing Part A here today, which is not what was envisaged. It was not what was...
But I mean, do I need to look at the prospects of success on Part A? Not...
Your Lordship looks at them in a very cursory way, only to decide whether there's a triable issue. not whether there's a prima facie case or anything approaching that kind of standard. In other words, to come within Section 34, a different way to look at it, my lord, if one looks at the language of Section 34, is for your lordship to be persuaded that there is a dispute and which can be resolved by the application of law.
And I've looked at the case law and so on. Can I just ask you, you know, this is an unusual event today in the sense of the relief that you seek pending the first part of the main application, which you also refer to as being of an interim nature. But well, maybe I shouldn't ask it. Now, let me just listen to your argument first. Before you do that, Mr. Barner, I'll just have another thought, and then you can go on. You know, this court is overwhelmed with applications, as you know, and overwhelmed with urgent applications and trials and so forth. If for that reason a deputy judge president gives you a particular date, you know, like in this case, only in December, and you, when I mean you, any party, not particularly this one, any other party, is of the view that it is severely prejudiced by the allocation of that date, would it be open to that party to come to an urgent court and say, I've been allocated a date 3 months hence. My position at the moment is so critical that that allocation needs to be changed and I need to be heard this week in the urgent court. Can that be done in terms of the rules of court?
I suppose one could. What is clear on the facts of this matter is that there was no prospect of that happening, firstly. And secondly, the respondents themselves frustrated the hearing that was to take place in that week of the 14th. There were two factors, my lord. One is we needed a special allocation, and the court indicated what your lordship is aware of. But secondly, my lord, the respondents very strategically maneuvered themselves and ensured that they would not file their answering affidavit timelessly, that on the Tuesday when the matter was heard, there was no answering affidavit before court. But, of course, they would tell the court, we're filing an answering affidavit in the next day or two. So faced with that, very few courts would say, well, I'm deciding this matter only on a matter of this nature, only on the applicant's papers. And we say that that was... I
want to be careful. I don't want to confine it to this case. If any applicant is given a hearing for, say, December, and that applicant's particular situation is so critical that it deems that that date won't safeguard its rights, would it be entitled in terms of the rules of court to come to an urgent court, obviously to make provision for an answering affidavit and a reply? In other words, come to court within a matter of 10 days and say that allocation is so unreasonable because it won't safeguard my rights. I can't see any reason why not. I know it hasn't happened to my knowledge, but nothing prohibits it. Nothing prohibits that.
Practically, we know that can't happen, because of what we were faced with before the DJP mode.
As I say, forget about this. What happened here in August. Any other applicant under these critical circumstances, in my opinion, would be entitled to come to court and say, the allocation that I was given 3 months' time will ruin me forever. I want to be heard this week, and obviously make provision for an answer and reply. I mean, that can be done conceptually, no doubt. Yeah. But you say You wouldn't have a judge,
given a judge to hear the matter.
but the urgent judge would hear.
We were told, my lord, that this matter would not be heard by an ordinary urgent.
Yes, but that is not the... No judge can prohibit a person coming to court by way of urgency. How that is dealt with once it's before court, of course, is another question. But I can't imagine any judge, be it the judge president or the deputy judge president, saying that you're not allowed to come to court by way of urgent application.
I don't want to anticipate what your lordship is putting to me, but having said that, it seems to me that what your lordship is grappling with is the issue of access to court in the context of Section 34. And we say...
in general, also in terms of the rules of court, yes.
When we say notional access, it's conceptual access in the way your lordship is not the way you view Section 34. Section 34 must be applied in a way where there is real and effective access to a court. And real and effective access to a court means you've got to take into account the fact that there will be a judge allocated to hear the matter, and that court can make an effective order.
Yes, but we know, of course, that every day in the term and even outside the term, there is an urgent court and an urgent judge, if I can call it that. So there is access.
But, my lord, the access has to be meaningful access, and that's what I say to your lordship. The access must be meaningful access, real access. Not notional access that, well, you can get to court, because on that argument, my lord, on what your lordship puts to me, one would say, well, you have access to court because you're going to have your matter heard on the 7th and 8th of December. Now, notionally, that's access to court. On a very superficial level, one argues that Section 34 is satisfied because you're going to have your day in court on the 7th and 8th. But the issue is that day in court is meaningless because the court can't make an effective order. So when you look at Section 34, you cannot divorce from it the fact that the court, that access means access to a court that can make a meaningful order.
Just a moment. Cannot make a meaningful order. And what test would be applied for that? An objective test or a subjective test?
Lord, it's
Many parties come confronted with an order, they walk out the front and say this order is meaningless.
meaningful in the sense that the order that the court makes is not in relation to a moot issue. And that's not something that we conjure up, my lord, in the authority which we take your lordship to, and I'll take your lordship to. The academic writing clearly indicates unequivocally that that's how Section 34 must be interpreted and applied.
Yeah.
And we'll also take your lordship to some of the case law in that regard.
When I say yes, Mr. Bonner, I don't mean I agree necessarily. I'll decide later. But I hear what
I say yes, I will say yes in that way.
No, I know that. I don't want to be misunderstood. I often say yes, but that doesn't mean to say I agree. Well, yes, well.
My lord, so we then submit that what your lordship must be astute to, my lord, is that we are not dealing with Part A today. Because that means, for a number of reasons, but one of them is, my lord, your lordship in deciding issues that may be relevant to Part A will really be usurping the function of the court that will be deciding this matter on the 7th and the 8th.
Tell me, yes, well, we'll get to that later on.
It's for the court to consider, and one can arrive at that in a number of different ways. But what the court should consider is that given its inherent power in regulating its procedure, and the fact that the court has now indicated that Part A will only be heard in December, can it and should it make an order which puts the court, the December court, if I can call it that, in a position to make an effective order when it decides the matter? And we say, my lord, looking at this through the prism of the traditional 3 requirements of an interim interdict, in the sense that your lordship is urged by the other side to decide the prima facie right for Part A, an irreparable harm and balance of convenience, is incorrect, because your lordship should not be considering that. It's the debate we had a little earlier, my lord, as to whether there's a prima facie right if Part A was being heard, because that is what is going to be argued at length in December when there are full affidavits before the court.
So I don't need to look at the requirements for an interim interdict.
Your lordship said to me, to the reply.
In today's hearing, I don't need to look at the requirements for an interim interdict.
We say you don't apply the 3 traditional requirements. We say when you're faced with the Section 34, what you've got to consider is there going to be a triable issue? What do I need to do to make an effective order? And will there be irreparable harm if I allow a situation to persist where the court hearing the matter can't make an effective order?
Just give me that again. I need to look at 2 requirements. Firstly, is a triable issue.
Essentially, the requirements of Section 34, which we set out in our heads.
I've read all that, and I've read those authorities.
Essentially, you've got to look at that, but the point is,
Right, so the first is a triable.
the second issue is that how does this court preserve its power to make an effective order when the matter is heard in the December hearing? And will there be harm to the applicants if they're not granted relief, so that the court hearing the matter in December will not be able to make the effective order?
So that would be point number 3 then. I must consider the harm to the applicants. Now, would that mean I need to consider the harm to the respondent?
We would suggest the following. Your lordship, as your lordship has said, in the exercise of her discretion, would always take those factors into account, my lord.
Do I need to look at the harm to the respondent?
Your lordship clearly would look at the balance of prejudice.
Balance of convenience.
Yes, because that is a factor that would go to your lordship's discretion. And you need not pigeonhole it as to applying the requirement of a traditional interim interdict, but it clearly is something that your lordship would not totally ignore.
So can I note this, that you say I can consider and I must consider the balance of convenience?
So it's a lower threshold to meet, my lord, in this instance.
And when I look at the balance of convenience, I mean, I know one weighs up the relative harm that may exist by looking at the facts relating to both sides. And you say that is then the discretionary part of my duties. And well, we get to the balance of convenience later on then. I understand your argument, Mr. Mbana.
In fact, if we can, perhaps before I deal with other portions of the heads, just take your lordship to, I think, paragraph 40 of our heads, where we deal with the decision of Judge Wallace.
Judge?
Malcolm Wallace. Yes, it is paragraph 40. It's Hotz versus the University of Cape Town. It's in footnote 25, my lord. It's 2017, volume 2 SA, 485 SCA at paragraph 39. My Lord, I understand our attorneys have prepared a bundle of authorities, if that would be useful to your Lordship.
Yes, I'll read those as well. Yes, I'll read those as well, thank you. So what does he say then, paragraph 39?
At paragraph 40 of our heads, my Lord, and the most convenient way would be simply to look at paragraph 40.
Sorry, say that again.
At paragraph 40 of the heads, my Lord, where he says, this understanding of the nature and purpose of an interdict is rooted in constitutional principles. Section 34 of the Constitution guarantees access to courts, or where appropriate, some other independent or impartial tribunal for the resolution of all disputes capable of being resolved by the application of law. The Constitutional Court has described the right as being of cardinal importance and foundational to the stability of an orderly society, as it ensures the peaceful, regulated, and institutionalized mechanisms to resolve disputes without resorting to self-help. It is a bulwark against vigilantism, chaos, and anarchy. It goes on a bit, and the portion that we want to emphasize is in the last sentence. In granting an interdict, the court is enforcing the principle of legality that obliges the court to give effect to legally recognized rights. In the same way, the principle of legality precludes a court from granting legal recognition and enforcement to unlawful conduct. To do so is the very antithesis of the rule of law. And, my Lord, that really gives your Lordship the parameters. What your Lordship is dealing with, my Lord, is the question of the rule of law and the principle of legality, which always comes back to the fact that the court should be in a position to ensure that it can grant an effective remedy, and that the right of access in Section 34 is therefore not just a conceptual or illusory one, but a real one. Lord, if we can then turn to the earlier sections.
Can I just ask you this, Mr. Bonner? Will you at some stage in the time allocated to you say something to me about the balance of convenience? And then, of course, in that context, one would need to look at the rule of law considerations or not. On your argument, yes.
Your Lordship,
When one weighs up the balance of convenience, as you say that I must do, would one then take into account rule of law considerations?
The way it comes up is this, my Lord. Unless there's some very, very compelling reason, my Lord, the rule of law notion and the right to effective remedy and access under Section 34 really trumps that. So we don't suggest that your Lordship has absolutely no discretion, but you will not likely deny the applicants the right to get an effective order in due course, my Lord.
Yes, but that is so. No doubt any court would not likely deny a person an opportunity to get proper relief in a court. What I'm asking is, when I consider the balance of convenience, can I consider rule of law aspects?
Elaborate on that. I'm not sure I'm following the question.
In other words, if on the papers, it is my opinion that the one party is attempting to uphold the rule of law and the integrity of the financial system in the present context. And on the face of it, there are indications that the other party, by its conduct, has or will undermine the rule of law. Can I consider that when I look at the balance of convenience?
The integrity of the financial system, my Lord, we say is not the rule of law consideration that the cases have in mind and Judge Wallace has in mind. We also say that those aspects have not been dealt with, my Lord. There are allegations made in the answering affidavit which have not been replied to, because essentially they go to the argument the December argument. So, Your Lordship, firstly, it's not an application of the rule of law principle on the basis that Your Lordship puts it to me. But secondly, my Lord, there are all of those allegations to which there are very good answers which haven't been answered as yet because of where we find ourselves.
Well, that is one reason why I asked you up front that why in the last month there was no reply filed. So you say I can't consider rule of law.
To have a hearing on the interim issue
Yeah.
was made clear by the DJP could be on there was going to be no further exchange of papers before that hearing took place. So we were put between a rock and a hard place. If you say you're going to reply to that, then I can't accommodate you on an interim in the way he was going to do so by hearing this on the Thursday.
Just a minute, let me just make a note. Now, can I get back to my my question? When I consider the balance of convenience, like you said, I must. You say I need not look, I must not look at rule of law considerations.
In the manner Your Lordship has put it to us, that the upholding of the integrity of the financial system, we say that is not the rule of law notion that is envisaged in Section 34. But, my Lord, we will also, if it is a factor that is, we say Your Lordship doesn't approach it in that way. But factually, my Lord, we can answer that on these papers. We can show Your Lordship that all this prejudice and all this atmosphere that they create, my Lord, is all just atmosphere and noise. Because when we take you to the chronology from at least December 2015, the 15th of December 2015, they've been aware of the risk, the political risk, the fact that they were dealing with what they term to be politically exposed persons. That is 18 months ago, my Lord. And then...
Meantime, they took steps to, they say in their papers that they've managed even to I think it was either 1.2 or 1.5 billion rand that was recovered.
What they did was they also opened other accounts, and they also took more than 10 months from taking the decision, they say, to the exit decision to in fact serve the notices of termination. And perhaps it's useful while we're having this discussion for me to take Your Lordship very briefly to the chronology.
Yes.
I'm not going to deal with every item, my Lord, but there are a few that I wish to highlight. And Your Lordship will see the first item is in October 2015. The respondent performed an evaluation of the applicants and concluded that they pose high risk and were politically exposed persons. We've given Your Lordship...
I've got that 15 December.
And
Yes.
we've given Your Lordship the reference to that in the papers.
Right.
So, October 2015. Then, December 2015, Mr. Singh of the respondent writes recommendations to the local CEO of the respondent that the applicants be designated as PEPs, politically exposed persons. And then an important date for Your Lordship. On the 15th of December 2015, the CEO approves the classification as posing high risk. So all of the noise that they make and that they say is such a problem, they've been aware of for at least 18 months before the notices of termination. Then, my Lord, your Lordship can peruse the rest of the items until I get to May 2016 at your leisure, but essentially what it deals with is all of the other major banks giving notices of termination and terminating the applicant's facilities. We say again the relevance of that is that you're now aware, if you, Bob, as we call the respondent, you're aware as Bob that the major banks have now taken all of these decisions to terminate. Yet there's no decision to terminate taken by Bob, and all of this is going to be a build-up, my lord.
When was this awareness?
It's from the ABSA termination on 18 December 2015. It's item 4, and it continues until May 2016.
ABSA was February 2016. First National April 16, is that right?
Yes, there's a net bank before that, my lord. Sorry, your lordship's correct. First National April 2016.
Nedbank was also
Nedbank.
April 16.
Standard Bank.
When was Standard Bank also April 16? Can I just ask you, I don't know whether it's important or not, why were no applications brought against
Well,
those
my
banks?
lord, one has to deal with what the position the respondents were in. At those points in time, they had alternative banking. Had they gone to court, they would immediately have been met with the issue. But you've got alternative banking, you've got an alternative banker here. And that is what is so critical about this matter. Effectively, the Bank of Baroda, my lord, is really the last chance that the respondents have of having any current banking accounts that the applicants have.
No doubt we'll get to the debate about the agent banker, if I can call it that.
Mr. Daniels will deal with that, my lord. I will say one thing, my lord, there in that regard, and I'll leave it to Mr. Daniels. When you look at the issue of the paying agent, my lord, the paying agent can never act as a banker. So there's certain instances where, with the permission of the other side, one can use the paying agent. But the minute the paying agent conducts itself as a banker, in the sense of regularly taking deposits and making payments, it runs foul of the Banks Act, my lord. And if there's time permitting, I'll take your lordship to the annexes which show that this.
Mr. Daniels can deal with that.
Indeed.
That topic, if
So
that's
to
his
come back
part.
to the chronology, my lord.
But I mean, it has happened in the past in these papers.
The,
Paying agent has made certain payments on behalf of certain applicants.
my lord, there's the SARS payment, which is really an exception, and you've got to get the consent. The problem with that is you've got to get the consent of the other party. So effectively, if you're making, for argument's sake, 5,000 payments to different people and employees, to go and get their consent each time is just practically unworkable. It's the one point. And the other point is that the minute, if we have time, we'll take your lordship to the Banks Act. The minute an institution, as a regular conduct of its business, starts taking deposits and making payments, my lord, that institution then is classified as a bank under the Banks Act and is in contravention of the Banks Act. If I have time, my lord, I will come back and deal with that subject to what Mr. Daniels may say.
But it's also part of the balance of convenience consideration.
Yes.
Because they say you can pay your 7,000 something plus various other parties shouldn't be
Yes. My lord, it's fallacious and it's misleading, and Mr. Daniels will deal with it. And if I have time, I'll also take your lordship to some of the annexes where, from their own papers in the answering affidavit, your lordship will see what the problem is with the paying agent. My lord, to come back to the chronology, the item I want to then highlight to your lordship is on page 3 of 3. the 30 May 2016 annotation. 30 May, and your Lordship sees that Bob opens new accounts for one or some of the applicants between 25 December and 30 May. The last new account opened on 30 May 2016. My Lord, all of this is going to be a build-up to showing your Lordship that for the respondent to say it's going to suffer such severe prejudice between 30 September and the first week of December, 2 months in a week, when it firstly has done nothing for 18 months after identifying these parties as high risk and PEPs. In fact, barely a month before the termination notices, it's opened further accounts for these entities.
Can I just ask you the prejudice aspect? Is that an objective test or a subjective test? In other words, the court has the power to say to a bank, you know, your considerations about your reputations are not objectively justifiable. Or must I leave the bank to run its own affairs, and if it feels that its own reputation is being hurt or harmed, to make the appropriate decision? In other words, what power does the court have to tell a bank, you know, your business decision to me as a court, you know, I'm not a banker, seems to be objectively unreasonable?
Your Lordship cannot say so, that they're suffering such grave reputational damage that they cannot keep these accounts open for 2 months. Yes. Your Lordship tests what they tell your Lordship.
I must now become the CEO of a bank.
To see whether there's any veracity to what they say. It's not your Lordship taking a business decision, but your Lordship has to ask, if you tell me you can't keep these accounts open for 2 months till December because you're suffering such great prejudice, how do you explain the fact that you've done nothing on certain markers from the for the last 18 months and on other markers which I'll take your Lordship to for the past 10 months? And therefore, your Lordship is entitled to ask and should ask that when you as Bank of Baroda tell me you're going to suffer such great prejudice, how plausible do I find that? And even if there is prejudice, how great can that prejudice be when you've done nothing either on 18 months, on the 18 months period or on the 10-month period for the next 2 months? And my Lord, remembering this, that in